Hello, 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 hello. All right, good afternoon, everybody. I apologize for running behind schedule. Please accept my apology. Thank you for joining in. Please just say hello, let me know that you are here with me. This is Free Legal Aid with Dorcas on Rant HQ. Thank you everyone for staying tuned. Again, my name is thank you for joining in. Again, my name is Dorcas. I am a barrister and solicitor of the Supreme Court of Nigeria, and I major in matrimonial courses, child rights acts, and then every other area of law. I was here 2 weeks ago and we had the discussion on what are the legal effects of marriage under the Act. That is what is called in general parlance court marriage. So we're able to look at what are the legal effects. And then after that broadcast, I had a lot of inboxes of people who want clarification on issues that has to deal with dissolution of marriage, issues that has to do with separation. So I thought to myself, we need to come back and have an open forum and discuss that issue. So today we're going to be looking at what are the things you need to know about divorce in Nigeria. Divorce under the Nigerian law, what are the things that you need to know? Please, as we go on, if you have any question, please drop your question. For those that didn't join us the last 2 weeks, what we look at was the legal effect of marriage under the Act. What are the rights, what are the benefits that marriage under the Act confers on any party to it? And one of the things that we looked at was that cohabitation then becomes as of right, even though people do that today. Mutual defense, that is, you are expected to look after each other and take care of each other. Then we looked at, okay, there's defense to property and there's citizenship. Then we said that really the rights under marriage under the Act really is conferred perhaps when, hello Precious, thanks for joining in. The right really inures maybe after the death or the separation or dissolution of the marriage. So what we are going to look at today is divorce under the Nigerian law. What are the things that you need to know? Because I got a lot of inboxes from people after the last broadcast and has a lot of issues around that area. So I'm quickly going to look into that. Divorce under the Nigerian law. What are the things that you need to know? So those are the things that we are going to be looking at today. Now, like I said at the last live show, under the Nigerian law, understand that if under any law, marriage under the Act is a contract. It's a marital contract. That is, two people coming together to contract, to agree to say that they want to get married to each other, and then the law provides for them what are the rules, what are the things they're going to look at. At the same time, there is also the law, in the same law, which makes sense to understand that when there is a breakdown, when there is a breakdown of this contractual relationship, these are the things that the court will look at. These are the reasons under which you can come. Thank you, Sister Molewa, for joining in. I appreciate you. These are the things that the court will look at before they can consider or look at it and say that the marriage has broken down irretrievably. So that is what we are going to look at. So divorce under the Nigerian law is called dissolution of marriage. For your marriage to be dissolved, for the court to consider your marriage as eligible for dissolution, there are things that they are going to look at. So those are the things we are going to look at. Divorce is defined as the legal dissolution of a statutory marriage by a court of competent jurisdiction, a court of competent body. That is, you cannot just assume that you are divorced. No. Divorce is the legal dissolution of your statutory marriage, of your marital contracts. So you cannot just assume that you are divorced. Please share these videos. Please share this video on your wall. Please share on your wall. So you cannot assume. Hi, Abuchi from Ghana. Hello, thank you for joining in. So you cannot assume that you are divorced. The fact that you have lived separately, because I have a question around that, the fact that you have lived separately for 15 years, for 20 years, as long as you have not approached a court of competent jurisdiction for them to dissolve your marriage, please, you are still legally married. Take it. And if anything happens to the two of you, if anything happens to either of you, the other party under the law will be recognized. So that is why it is important for you to ensure that if you know that you want to go your way, the marriage has broken down irretrievably, either party is not no longer interested in the marriage, please take that step. I know there's this myth of who is going to file. Anybody can file as long as you know that the marriage has broken down irretrievably. You have lived apart for 5 years, 10 years, and then you are not dissolving what is in between the two of you. If anything happens, the other party takes benefit of that. So divorce is defined as a legal dissolution of a statutory marriage by a court of competent jurisdiction, irrespective of how many number of years that you have been separated. Now, the other question which a lot of people are scared of, this 2-year, there is a 2-year rule under the Nigerian law as to divorce. That is, the court expects that before you bring a petition for dissolution of marriage, you must have at least lived apart for 2 years. That is, within those 2 years, you have tried all reconciliation mechanisms and it has not worked. And then you have lived apart. That is, conjugal rights, conjugal benefits are stopped for that 2 years. That is when you can come to court and say that this marriage has broken down irretrievably in the last 2 years. We have not lived together. We have tried to sort out our issues. It's not getting solved. We want the court to dissolve this marriage. So that is what the 2-year rules is about. So really, you cannot just say that because your spouse left home a year, 2 years, just in some few months, maybe you had disagreements and then they left and then that's the end of the marriage. No. You must have lived apart at least 2 years before you can bring a petition for dissolution of marriage. Please, as you are having your question, please ask as we go on. I'm going to answer your question. Now, what are the grounds on which you can bring an application or a petition for dissolution of marriage? What are you going to look at? What are the things that the court will consider and say that indeed this marriage has broken down irretrievably? One is that there is willful and persistent refusal to consummate. That is, if your husband or if your wife or your husband is refusing to have sexual relation with you since the marriage commenced, you can go to court and say this marriage is not working. And let me quickly inch something here. If you got married and perhaps it is by reason of deceit or default or fraud, because I've had somebody ask me a question in my inbox after the last meeting. They got married and then the woman was not made aware that the man was impotent, and then it was after they got married that she became aware, and then the man was refusing even to go for medical attention. Please, the law is that within that first 1 year, you can quickly bring an application for that marriage to be nullified. If it passes 1 year, you are going to have to file for divorce. Because I know that when things happen like that, first place of call, people like to, maybe you've gone to your pastors, you've gone to, and then they say pray about it and all that. What you need to understand legally is that if you got married on the basis of pretense, on the basis of deceit, that is, you are not made aware that this person has a medical condition that is going to affect a lot. It could be man or woman. It doesn't have to be a man. It could be the woman. Maybe the woman had a medical condition that maybe her womb has been removed or something, and then cannot be able to conceive or anything whatsoever, or whether it is even mental disease, but that you are not brought in the know before the marriage. The law allows you within the very first 1 year, the first 12 months of that marriage, to quickly approach the court for that marriage to be nullified, because that marriage is void ab initio. So that is that. So like I said, if there is willful and continuous refusal to consummate, your husband refused to sleep with you, your wife refused to have sexual relationship with you, it's a ground for you to bring an application for divorce, that this marriage is not going to work. Also, on the grounds of adultery, that is, you know that your wife or your husband is involved in adultery, and then perhaps maybe you have even caught them in the act. It's also a ground with which you can bring an application for divorce. And then the law puts a clause that it's an adultery that you find intolerable. Some people, maybe you know that your husband is cheating and you don't mind. The law also doesn't help you mind. You can stay there. But once you find it intolerable, maybe your husband has gone to give birth to a child outside, and then you find that intolerable, it affects you psychologically, the law allows you to bring an application for dissolution of marriage based on that. But then you have to prove that indeed there was an adulterous act. Then also, there is this general ground, that is where the respondent, that is the hearing spouse, now has behaved in a way that the petitioner is not reasonably expected to live with him or her. And what are these unreasonable way of living that the person is not supposed to live with? Maybe the person is a drunkard. Maybe anytime he gets drunk, he always gets into police issue. Maybe he goes into, maybe he's very, very violent, He's always in police custody. He goes in and out of police custody and all of that. When he behaves in such a way that a reasonable man is not expected to live with that person, then you can also bring, you are allowed under the law to bring an application or a petition for dissolution of marriage. Shosko is asking, is this includes marriages as church or only court marriages? If your church is licensed, in any ways, you are advised to get married in a church that is licensed. That is when your marriage is valid and legal in law. So if you get married in a church that is not licensed and they just give you church marriage register, fine, you can abide by their law there. But once you get married under the law in Nigeria, I'm telling you of what options that are available to you when the marriage has broken down irretrievably. Also, where you have been deserted for a period of at least 1 year, where your spouse, whether the husband or wife, just disappear. You cannot reach the person. You have been deserted over a 1 year. All this marriage that the husband is in America, the wife is in London, you cannot reach each other. There is no communication. You don't know what is happening. Under the law, when there is desertion, when you can prove desertion, that is, you do not know where the person is, you have not spoken to the person has just tried to reach you in 1 year, then the court allows you to bring a petition for dissolution of marriage. Also, if that desertion gets to the point of 7 years, the court assume, or the law will assume, that party that has deserted the home as dead. So there is a presumption of death after 7 years of desertion. So we need to put all of these things into mind. So with that, you can also bring an application for dissolution of marriage. Like I said ahead, if you had lived apart for 2 or 3 years or more years, you can file a petition for dissolution of marriage. Now, where perhaps a party to the marriage had filed an application before the court saying that my husband or my wife is not granting me consummation or conjugal rights, and then the court makes an order that, Shamel John, thanks for joining in, and then the court makes an order for conjugal rights to go and resume, and the party is still refusing, you can bring an application for dissolution of marriage. Hello Gift, thanks for joining in. So also, where there's the case of rape, there's the case of sodomy, there's the case of bestiality, you can bring an application for a dissolution of marriage. If the person is an habitual drunkard, is a druggie, is a narcotic, he used drug, he stimulates himself by drug, and then you've watched that for at least 2 years, the court allows you to bring a petition for dissolution of marriage. The person is a frequent criminal, he's always in court, he's been convicted by court to go to prison, he's back and forth, and within 5 years these things are not stopping. You can also bring a petition for dissolution of marriage. The person has been convicted for attempted murder, unlawful killing, where you feel that there's a threat to your life within the first 1 year of the marriage. These are the exceptions to the 2-year rules, So where you feel that there's a threat to your life within the very first 1 year of the marriage, the law allows you to bring a petition for dissolution of marriage. Then when there's mental illness, and there is unlikely that for the party to recover, where it's unlikely for the party to recover, the law allows you to bring a petition for dissolution of marriage. So these are the general rules around dissolution of marriage. So I think I really taking time to look at that. So if you find yourself around any of these issues, and then you are confused as to what step to take, you can still speak to me inbox, but these are the general rule as regards dissolution of marriage in Nigeria. These are the general rule that you need to know. So let's take our questions now. If there's any question that anybody wants to ask, please ask me now. Apart from infidelity, which other grounds can one seek divorce? Eric, I've said it. You can seek divorce, on the ground of willful and persistent refusal to consummate, adultery, desertion, failure to comply with the order of court, if you have lived apart for 2 years, or there's an issue of rape, sodomy, or bestiality, all these are issues. The person is an habitual drunkard, the person is a druggie, he used drug, is a frequent criminal, he's been to prison and back, and then you cannot wait, you are allowed to bring a petition for dissolution of marriage, where the hearing party has also refused to maintain you, where maybe the husband or the husband now deserts the home and has refused to maintain the home for at least 2 years. The law allows you to bring a petition for dissolution of marriage, and when there is mental illness and then the person that is sick is unlikely to recover, you are also allowed to bring a petition for dissolution of marriage. Please ask your question. Let's take question. I said, okay, Kingsley is asking, what is the wife change religion or the husband? Can divorce be applied? Change of religion, I don't think is a ground for dissolution of marriage. Under the Constitution, every Nigerian has a right to religion. So the fact that your wife from a Christian becomes a Muslim, if it's not causing you any harm reasonably, I don't think that's a ground for dissolution of marriage. But if you think that based on that the marriage has broken down irretrievably, all you need to do is just to exhibit to the court how that you cannot reasonably live with that person because of his faith, and then the court would hear you. Hi, boss, thank you for joining in. Been a while. So that's that about that. I'm going to be taking questions. I have quite a number of questions from my inbox. And like I said earlier, the fact that you have lived apart for 5-10 years does not mean that you are legally divorced if you have not approached a competent court. So do not be deceived that we have lived apart after 10 years. It doesn't mean until the court pronounces that marriage as dissolved is still subsisting. So thank you, Olawale. Maxi Biodun is asking, please, is it a must names of children are listed in dissolution of marriage? Yes. Now let's talk about the procedure. When you file an application for dissolution of marriage, there are paragraphs that you need to fill. The first thing you need to show to the court is that, one, at the time you were single and this was your name when you were single, and at a particular date you got married to your husband or your wife on this particular date. And then you explain to the court that you've been married and you have lived in these places for so number of years. And then you tell the court that these are the children of the marriage. It is necessary that you name them and put their age. The reason is because that is one of the germane things that the court will consider in granting the dissolution of that marriage, because the maintenance of the children of the marriage is very, very germane. So the court needs to know their name and their age. And this is one area that brings the issue of custody. If they are still a minor, if these children are still within the minor age, the issue of custody would be considered, and then what is the arrangement that the petitioner is making for them, where the petitioner is the father, because it's expected that he is going to maintain the children. So their names are going to be put there. Mazi Abiodun, I've answered your question. Asuko, you are asking, the court with the jurisdiction to nullify or dissolve any marriage is the High Court. That is the High Court of any state. So it doesn't matter whether it's a Catholic wedding or it's an Anglican wedding or it's a CAC wedding or it's a Pentecostal wedding. It does not matter. All these churches are licensed. I know the Catholic Church is licensed for marriages. I know the Anglican Church is licensed. I know the Christ Apostolic Church is licensed. All these churches are licensed. That means that they are just licensed place of worship where marriages can be carried on. The certificate that is given to them there is still the same certificate that will be given to you at the registry. And which court has the jurisdiction is the High Court of any state. And the jurisdiction for matrimonial causes is one. So it doesn't matter that you got married in Lagos, you can go and dissolve your marriage in Ibadan. If you got married in Ilorin, you can dissolve your marriage in Kwara, in Ekiti State. It doesn't matter. It is possible. There's Shamel, I'm trying to answer your question. It is possible that there is what is called spousal rape. Spousal rape is very, very real. It is possible, and it is a ground for dissolution of marriage where it is properly established. Kingsley, you are saying, what if you pardon her? If you have not approached any court, in fact, if you approach a court today that you want to dissolve your marriage, and while the proceeding is going on, both of you settle your issues, fine, you just come to the court and then you strike out your dissolution of marriage. If again you feel that the marriage has broken down, you come back again. What you need to just tell the court, at a time we have been here, but we stop the proceeding. So it doesn't matter. But once when you now do what, if you continue to do that over a frequent time, the court is going to have to stop you to know what you want to do. So the fact that you commenced a proceeding for dissolution of marriage and then you not conclude it is no reason why you cannot bring it back. Please, let's start our question. You're asking, can a woman ask for dissolution of marriage on emotional separation? Now, what the law, that emotional separation under the law will be considered as what's it called? As not, as a failure to apply conjugal rights, because conjugal rights is not limited to sexual relations alone. So really, when the wife or the woman now can establish that indeed there is no longer an emotional connection in the marriage, that is, the husband, they just live under the same roof, they do not do a lot of things together, the marriage has broken down, there is no communication, there is no companionship, all of this can be established, and yes, it could be a ground for dissolution of marriage. On the certificate for dissolution of marriage, when the court grants an order for dissolution of marriage, what they first of all do is they grant an order for an order nisi, and then after 6 or 3 months, depending on what the court considers in that case, they make the order absolute. Now, there's going to be a judgment, and then there's going to be the order drawn out. In the judgment, the court is going to explain what his decision is on the maintenance of the children, and yes, their name will be contained in the judgment. But in the order, no, their name will not be, because the order nisi is just a form that the court draws out and says that the judgment was given on this date, and that is the order nisi, and then the order will be made absolute on so date. That is what is contained in the order nisi. The names of the children are not there. Yes. To contact me, please send your emails to AAO. Okay, let me put it there. My email, AAO Legal Practice. That's my email, so you can send me. Your question there. Like I said in my earlier post, I have a page that I also run on FB, Ask the Legal Practitioner. I have a lot of all these resources to answer a lot of questions regarding matrimonial issues, regarding Child Rights Act, regarding your employment issues. Please do well to find this page on Facebook, like us and follow us. There are a lot of these resources to help you there. Ask the Legal Practitioner. That is the name of the page. Ask the Legal Practitioner. And then we have a group, where you can ask your question freely and then you'll be answered. And then we have a team of lawyers who can help you out wherever you need them. So ask the Legal Practitioner. I'm also on Instagram, Wonder241. You can follow me on Instagram. I'm on Twitter at Atinuke Wonder. You can also follow me on Twitter. So I think I've answered all of our questions. So I'm going to be wrapping up now so that I'll be out of here. If you have any other question, you can ask me inbox. But I think I've taken all. Another thing that I quickly want to, talk about in the issue of dissolution of marriage, because I know a lot of people have been married for a long, I've had to deal with a marriage of 21 years, and then they want to dissolve the marriage, and then the issue of alimony, the issue of maintenance coming. The law in Nigeria is so light when it comes to the issue of alimony. Why? Because it's not enough that you have been married for 20 or 21 years or even more. It's not enough. It is important that as you are going on now, let me make that as an advice. As you are going on now in your marriages, ensure that when documents for properties are being prepared, please take care of yourself. The reason why this thing is important is, like I said, in the face of the law, marriage is a contract. First of all, a contract. So when you are preparing documents for properties that you are acquiring, don't just put Mr. O and Mr. So and so, and that is all. You just go and do Mr. and Mrs. So and so. At the end of the day, even if it is not for dissolution of marriage, it may not count well. So when you want to prepare documents for properties or anything that you are acquiring, make it clear. Mr. Oluwa, so, and Mrs. Ade something. Make it on a very clear term like that. And also, men, because I know men too, some men claim alimony, some men, ensure that you contribute. Because what the court wants to see is that it's not just because you got married and then you are entitled to. No. You must show that you also contributed to acquiring that property. So when you file for dissolution of marriage and then you are seeking for alimony, ensure that you have proof of those things. Don't just be married and then you close your eyes. Is your husband that is in charge of everything. Is the one that knows when they bought the land, where they bought it. Please try put your nose into all of these things. It helps you. Like I said, it is not for dissolution. The reason why you are getting knowledge about these things is not for dissolution of marriage. The ultimate of a marriage is not for dissolution. If it breaks down irretrievably and you have to step out of it, it is for your good. But if then it works, even at the end of the day, whichever party lives first, by reason of death or anything, then the other party is taken care of, particularly for the maintenance of the children. We have seen a lot of people who married and then the husband died, and then the husband's family or any other interested come out and then they claim everything the man has, and then they leave the wife and the children in abject poverty. Why? Because the woman has not, ensured that details are kept. So these things, they have a lot of faces to them, and they are very, very, very important. So once again, thank you for joining in. I appreciate everyone who has been a part of this show. I'm sure every one of us has gone home with one thing or the other. But like I said, do not forget, when you get married under the law, it's on yours to use some rights. And these rights, please ensure that you get yourself acquainted to them. And then I've explained in this broadcast now on what grounds you can bring an application for dissolution of marriage. That is the general rule, and the things that you need to consider. Majorly the maintenance of the children and the issue of custody. If they are still minor, the court will tend to want to have them with their mother. But where it is shown that maybe the mother is of unstable mind, or whether she's mentally ill, or she's not financially strong enough to take care of those children, the court will tend to consider the overall interest of the children and put them where they are going to be best taken care of. So these are the things that the court is going to look at. And like a woman, as I say, as your marriage is going on. We pray everybody's marriage is successful as it's going on. Ensure you put your mind, ensure everything is put in details. It is to take care of your future, the future of your children, and the future of that marriage. Once again, my name is Dorcas. Thank you very much. I thank the board of Rant HQ for this opportunity again. It's always a pleasure of mine to be here. And then okay, I'm going to do that now, Biodu. It's always a pleasure of mine to be here and to share knowledge. I can always tell people, clear your doubts. A lot of people have a lot of doubts as regards the matrimonial issues and child rights in Nigeria. Ask your question, clear your doubts. There are laws that are lying fallow that people are not using, and that is for the benefit of everybody. My page again, Ask the Legal Practitioner. Sorry, I'm trying to put that there. As a legal practitioner is a page that is going to really help you on FB. Yes, it's on FB. I have a lot of these resources there. A lot of questions regarding matrimonial issues are answered there. So please do well to look out for it on FB, like our page, and follow us. Also, I'm on Instagram, Wonder241, and then I'm on Twitter as at Tinuke Wonder. So look out for me in all of these places, and then would get this done. I appreciate everyone again. Thank you so much. Thank you so much. I appreciate. So that's going to be bye for now. Thank you. Bye.